Alright everyone, so let's continue with our current affairs lecture series, and today we are going to cover Indian polity related current affairs. So all the important news items with respect to Indian polity from the past 1 week shall be covered in today's lecture. Okay, now before beginning this lecture, I always say this statement, so I'm going to say it again. Make this lecture series a part of your daily routine. It should be a daily habit of yours. Current affairs should be a daily habit. Only then you'll get a hold of these current affairs, and this will really serve you well for your UPSC examination. The reason is 50% of your UPSC exam, whether it's prelims or mains, comes from current affairs. It is from current affairs. Even your static portion is somehow related to current affairs. Therefore, my sincere advice would be make this lecture series a part of your daily routine. All right then, enough of the introduction. Let's straight away dive into today's lecture. So let's begin. So current affairs, Indian polity, July part 4. And here are the topics that we are going to cover. So number one topic is the recommendations of K. Radhakrishnan committee report, because this report is in the news. And why? Because this report recommended various changes in national testing agency responsible for these national exams like NEET. Okay, so we need to talk about this. Then topic number 2 is related to legal challenge to surveillance and facial recognition, because, well, allegedly Delhi police is using facial recognition technology on protesters who gathered at Jantar Mantar. So we'll talk about this, okay, whether it's a breach of right to privacy or not. Then we'll talk about right to legal aid and de novo trials. De novo trials is an important keyword that you need to remember. Now, Supreme Court recently gave a judgment related to this. So we'll talk about this. And in the end, we'll talk about curfew law in India. Curfews are imposed in India by the police. So what is the legal architecture of imposing curfews? We'll talk about this also. So these are the 4 news items that we shall zero in our attention on. So let's start discussing them one by one. Starting with topic number 1, and that is K. Radhakrishnan committee report. We all know that National Testing Agency requires reforms. Now, government way back had formed a committee called K. Radhakrishnan Committee, which gave certain recommendations so that these exams, these national level important exams like NEET, well, they are conducted with utmost integrity and we can prevent paper leaks in future so that students' lives are not at stake, right? Now, this report is being debated. Right now, the government has formed another panel, another committee under Nandan Nilenkani. But before that committee sits and gives its recommendations, we need to talk about the recommendations given by prior committees in India. So in that regard, K. Radhakrishnan committee is important and its recommendations were really, really insightful. If Government of India had implemented them beforehand, maybe we could have avoided this catastrophe. All right, so let's talk about these recommendations. So let's begin. So K. Radhakrishnan committee report. Now, what was in the context? What is in the context? What's the context basically? Following recurring examination breaches, well, we have formed another committee, but we need to talk about K. Radhakrishnan committee. K. Radhakrishnan was former ISRO chairman. Now, this committee submitted its report and it gave a mammoth 101 recommendations. So, well, we can't get into or we can't talk about all these 101 recommendations, but we can understand the gist of the matter. Okay, so let's talk about this. So first of all, K. Radhakrishnan talked about examination security reforms. Okay, examination security evolution. So how can you secure examinations so that there are no leaks? So there are 3 ways. Okay, now number 1, if you are conducting exams which are physical exams, offline exams, not computer based, well, there were recommendations for that. Legacy pen and paper. Okay, these are high risk examination. Then the other recommendation was with respect to computer based exams. And then there was hybrid system, computer plus physical. Okay. Now in legacy pen and paper examinations, well, these are high risk exams. In fact, K. Radhakrishnan said that we should abandon them altogether. But if we are still using this mechanism, we need to ensure adequate checks and balances. Okay. Physical printing and multi-point transit. Because of physical printing and multi-point transit, it is highly risky. We can go to computer-based examinations. Okay, computer adaptive testing. The students would go to computer labs and give the exams. There would be examination centers which would host these computer labs. It is dynamic, candidate-specific questions from encrypted bank. Okay, then if you really want to conduct physical exams, follow a hybrid model, which is, well, CPPT model. what would happen is that you are going to conduct physical tests. So instead of sending question papers to different locations, you will send these question papers online and they would be printed locally 5 minutes before the exam in all examination centers. Okay. Now, if you are sending these question papers online, you'll use a encrypted link, right? Or this can be done, or you will take the exams in computer labs. The questions would be displayed on a computer screen, but OMR sheets would be given to students. Students would mark their answers on the OMR sheet looking at the question on a computer screen. This is the model. This is safer, right? Then, with respect to exam authentication flow, Digi exam model. Basically, this is to prevent not paper leaks, but this is to prevent unauthorized access to examination centers. Okay. Now, like we use Digi Yatri for air travel, we can use Digi exam. Registration phase, all candidates who are registering, well, their verification would be Aadhaar linked, their digital credentials would be saved online. Okay. Then when they enter the center, their biometric scanning, facial recognition would be done. And this is already being done. Post-exam admission. After, okay, this data would be saved. All the faces would be saved. Now, after the students have taken admission in different colleges, their photos would be matched with these, the photos collected at the examination center. AI cross-matching of exam day data with admission records. So it is multi-level checking. Continuous multi-stage verification replaces single-day identity checks on the day of the examination with continuous verification. Plus, you'll use AI-based analytics and biometrics. So we should create, like we have Digi Yatri for air travel, we should have Digi exams for examination. Then, restructure NTA. This is the biggest recommendation. Proposed NTA structural reorganization. So there should be an apex governing body in NTA, which would be led by a director general. That DG would be additional secretary rank. Reduce reliance on private outsourced vendors. Currently, in case of NEET, we used a vendor, private company, and that was a blacklisted private company, but that's a different debate. No private companies would be outsourced anything related to the exams. Plus, within NTA, create 10 verticals. Each vertical responsible for each function. So for testing center infrastructure, there is a separate vertical. For information security, online security, for vigilance and forensics, for R&D and mental health cell, create a separate mental health cell for students. Similarly, different verticals were also recommended, right? Now, K. Radhakrishnan committee gave 101 recommendations, right? And it also suggested a roadmap as to how to implement these 101 recommendations. So that implementation roadmap was also given. Mental health cell and tele helplines for students, for counseling of students and teachers. AI-enabled grievance redressal. If you have a complaint, if any student has a complaint, well, there is a portal and it is AI-enabled. Coaching institute regulation. Regulate coaching institutes like you have never done before, because most of the times coaching institutes are involved in paper leaks. So do that. And high-powered implementation steering committee. Create a high-powered committee and give it the responsibility of implementing all these 101 recommendations in a proper mission mode manner. Okay. This was the implementation roadmap suggested by K. Radhakrishnan. Now, the reason why we are discussing K. Radhakrishnan committee's recommendations is because, well, this question related to examination integrity can be asked in your mains examination. So while giving your way forward, while suggesting your reforms in your answer, you will quote K. Radhakrishnan committee's recommendations. Okay, so it is important from that perspective, right? All right. Now let's move on to second news item, and that is legal challenges to surveillance and facial recognition. Now, it was witnessed, it was seen, clearly seen that Delhi police was using mass surveillance and facial recognition softwares to track each and every protester. Now, if you are using mass-based surveillance softwares, techniques, and you are basically tracking each and every protester, that is a significant breach of privacy. And after Puttaswamy judgment of Supreme Court, right to privacy is a fundamental right. So surely, as soon as this news came out with respect to facial recognition being used by Delhi police, someone filed a PIL, public interest litigation, in the Honorable Supreme Court, challenging this this action by Delhi police. Okay, now the case would go on in Supreme Court, but we need to be aware of all the constitutional legal principles associated with it. Okay, so let's discuss this issue. It's an important issue. So legal challenge to surveillance and facial recognition. So the context, well, I've told you, the context is pretty simple. A public interest litigation filed by former JNUSU President Ashi Ghosh, and it was challenging facial recognition technology at protesters in Jantar Mantar. Okay. Now, currently, what is the surveillance system available with Delhi police? What surveillance system was used at Jantar Mantar? There were permanent towers, round-the-clock videography, and continuous recording was happening. Okay. Then there were mobile vans, Ikshana vans. 360-degree high-resolution cameras were there, which were giving live feed to command centers where high-level officers were sitting, monitoring the entire situation. Plus AI was used and facial recognition technology was used. Real-time biometric scanning, matching with criminal databases. And this is where the challenge has been posed by, well, a student in the Honorable Supreme Court. Clear? Because that student is alleging that this is a gross violation of our right to privacy. And right to privacy is a fundamental right now under Article 21, right to life. And this was done. I mean, when was right to privacy inducted as a fundamental right under Article 21? As per Puttaswamy judgment of Supreme Court. Okay, now, what are the constitutional issues attached to this mass-based surveillance or facial recognition technology? I mean, this petitioner who is challenging this action of Delhi police, well, he's challenging that action on what basis, what constitutional basis? So he says that, well, this facial recognition technology being used against student protesters, well, it is breach of Article 14, which is right to equality, because you're taking arbitrary action against some protesters and not take any action against other protesters. So protection against arbitrary action. Then Article 19, freedom of speech and expression is there, peaceful assembly is allowed. This is our fundamental right. Okay. By using mass surveillance technology, you are violating or you are deterring people from assembling peacefully. Okay. And Article 21, right to life with dignity. And since after Puttaswamy judgment, right to privacy is part of Article 21, so this is also under challenge by Article 21, right? Now, the question is, this is very important. Remember, I told you Puttaswamy judgment made right to privacy a fundamental right under Article 21. Yes? So nobody, no state can violate your right to privacy. But the Supreme Court was also aware of the fact that sometimes for public security, for sovereignty and integrity of India, sometimes privacy needs to be breached. Otherwise, law enforcement agencies won't be able to protect us. So Supreme Court knew that yes, we need to balance. We need to allow some state surveillance, but it should be balanced with everyone's right to privacy. So Puttaswamy said, not Puttaswamy again, Supreme Court said that, well, state can breach your privacy, but that breach should pass the triple test. Only then it would be allowed. Otherwise, the courts would cancel that order of the government. Now, what is that triple test? Okay. In the landmark KS Puttaswamy judgment, Supreme Court ruled that any state interference with right to privacy must satisfy this threefold test. Number one, it should be lawful, legal action. Okay. And the petitioner is alleging that there is no law for facial recognition technology. So it violates test number one as per the petitioner. Then legitimate state aim. Your action should have an aim, must serve a necessary public purpose. Okay, you can't randomly use mass surveillance. You have to prove that you are doing mass surveillance for public order, national security. So you need to state your aim and it should be a lawful aim. Clear? Well, the petitioner is arguing that, well, you can ensure public order and national security without resorting to facial recognition technology. Without that also you can do it. Okay. And third test is test of proportionality. The measure must be the least intrusive means to achieve the objective. If you need to ensure national security, well, it should be done through least surveillance method or least intrusive, which means find out other ways of managing national security rather than straight away going for, well, breaching right to privacy. This is the threefold test as per Puttaswamy, and the petitioner is alleging that, well, this action of Delhi police violates each and every test. Clear? Now, current gaps in surveillance, there is no dedicated law for facial recognition technology, plus Digital Privacy and Data Protection Act exemptions. Section 17 grants broad exemptions to government agencies. So currently there is no law for facial recognition technology, but under DPDP Act, well, there are some vague terminologies used which grants significant exemptions to security agencies. So security agencies are using this to use facial recognition technology. So there is lack of clarity. In DPDP Act, well, you say state can do this without mentioning facial recognition technology, but there is no proper law for this particular technology. Okay, so there is a legal gap. Now, this table will help you understand the arguments given by petitioner and the government's defense. Okay, so this table would be really helpful. So go through this table. It is shared in your notes. Most of these points have already been discussed by us. Okay, so just go through this. This is the argument. The second column is all about the arguments presented by the petitioner. And this is government's defense reply. Clear? Now, what should be the way forward? First of all, come out with a AI biometric surveillance law. There should be a proper law. Then, if you pass that law, security agencies would be allowed to go for biometric surveillance, AI surveillance, but that needs to be balanced out with independent audits, regular audits, whether security agencies are not breaching their limit. Okay, and institutional balance. Well, do go for security. Law enforcement agencies should be given power, but it needs to be balanced with right to privacy of individuals, individual rights. So achieve that delicate balance, and that delicate balance can be achieved if we make a new law which itself would balance security of state and individual rights of people. Make sense, right? That would be all. Now let's quickly shift our focus to next news item, and that is right to legal aid and de novo trials. Now listen to me very carefully. You know, if there is a criminal case against you, okay, and the investigative agencies did not follow the proper procedure while investigating the case against you, okay, and the matter goes to court, and if your lawyer presents this argument that, well, the investigative agencies did not follow proper rules, proper protocol. For example, when I was arrested, I wasn't given the opportunity to have a lawyer. This is a proper procedure that every policeman should follow. When I was arrested, I was not informed of the grounds of my arrest. This is something that policemen should follow. So if there is any procedural problem while the investigation was going on and the matter is raised by your lawyer in the court, well, the court can say that it's a mistrial. And even if you have done that crime, the courts can acquit you. Okay, this can happen. This happens all the time in the West. It's called mistrial. It happens in India also. But this time around, the courts have taken a balanced view. Given the seriousness of the crime, okay, the courts found out that there were certain lapses during the investigative process, during the investigation process. There were certain problems. But we cannot acquit these people because, well, as per our knowledge, we think these people are, well, guilty. So we can't acquit them, right? So what should be done? Well, you shouldn't acquit them, but you should give them all the rights that they deserve. So the courts order fresh trial in the trial court. Fresh trial. Try this person again, and this time around, follow the exact process which is written in the book. Now, these trials, these fresh trials are called de novo trials. Remember this term. Okay, so let's discuss this case and understand this terminology. Remember this word, de novo trials. Clear? Okay. So, right to legal aid and de novo trials. So, the name of the case was Dr. Abdul Hamid versus State of Rajasthan. The judgment was given by a 3-judge bench of Supreme Court, and it involved basically the lower trial court gave a death sentence. The case was this person and his accomplice, they were involved in a bus bomb blast in Rajasthan. Now, the Supreme Court realized that yes, maybe this person is guilty, but there is credible evidence that proper procedure was not followed. For example, he was not given the facility of a lawyer. Then there were other problems also. So the court, what have the courts done? Well, there were two accused. Dr. Abdul Hamid, well, he was convicted, death sentence. His death sentence has been set aside. De novo fresh trial has been ordered. And the reason given by Supreme Court was, well, he was not provided legal aid. He has the right to a lawyer. He was not given that. Then the second accused, Pappu Salim, sentence set aside and acquitted. Retracted confession lacked independent material corroboration. So his confession was taken, but it was changed multiple times. So this was the problem, and he is acquitted. This person is acquitted, but this person, de novo trial has been ordered. Now, what are the legal principles involved in this matter? So number one, fair trial is part of right to life and liberty under Article 21. Right to be defended by a legal practitioner, right to a lawyer is mentioned in Article 22 also. Plus, free legal aid, providing free legal aid to those who cannot afford a lawyer is a DPSP as per Article 39A. So as per directive principles, it is also the duty of the state to provide free lawyer to a person who cannot afford one. So all these were violated. Clear? That's what the Supreme Court has said. Make sense? Now, yeah, first let's take a look at the legal issue that the Supreme Court highlighted. What were the problems in this trial? First of all, retracted confessions. Retracted confession, especially when recorded repeatedly over long period, loses its evidence value. Okay. Then confession of co-accused. Well, this Salim, Pappu, Abdul, so a co-accused confession is not substantive evidence against other accused. One accused gave a confession accusing the other accused. Okay. So it shouldn't be regarded as a proof of high evidence value. This was there. This was used by the police. Disclosure, statement and discovery. Mere pointing out of public locations of scenes of crime by accused in police custody holds no evidentiary values. And you believe that confession because he said that I was there and I can say at that place there was a temple. So police said that this is a proof that this person was there and his confession has value. Okay, so this confession was given against Pappu. So that is why he is acquitted. Now the courts have gone for a delicate balance. Generally, whenever investigative process is not followed properly, the court calls mistrial and the person is acquitted. But the courts have said that we will follow the doctrine of de novo trial. We will balance because the offense is of exceptional gravity. So we cannot acquit this person. So we will order de novo trial, fresh trial. Okay. Now, we need some criminal justice reform so that this situation never happens again. First of all, this matter shouldn't have gone to Supreme Court in the first place. It should have been handled by the trial court, lower court. So trial courts should be extra vigilant whether each and every step of the investigation is being followed. Then, legal aid should be provided. Those who cannot afford free legal aid should be provided and the quality of that legal aid should be top-notch. Plus, investigation rigor over custodial statement. Police generally relies on confessions when someone is in custody as evidence. Well, police should rely on confessions. You can do this, but rely on other form of scientific evidence as well, like forensic evidence, okay, to prove your confession. The courts have made it clear that just if in the name of evidence you just have a confession, that is not that doesn't have good evidentiary quality. It needs to be backed by forensic evidence also. This is an important thing. Make sense? All right. And now let's move on to last news item of the day, and that is curfew law in India. So Delhi police announced curfew at Jantar Mantar, which means that, well, not many people can assemble over there. Okay. Now, curfew can be imposed by law enforcement agencies in different parts of the country. Police have that right. We need to be aware of the law that gives this power to a district magistrate, SDM, or any other authority to impose curfew. Okay. So we need to be aware of the law. Clear? So this is a short news item, very small. We won't take that much time in this. Nonetheless, you need to be aware of the law. So let's talk about this. Curfew law in India. First of all, you know about curfew, right? Whenever a curfew is imposed by the local authorities, not more than 4 people can assemble at any place. Okay. Now, the context is, during recent large-scale public demonstrations in national capital, the Delhi police imposed prohibitory orders under Section 163. Section 163 is, well, curfew orders. Section 163 of the new law, Bharatiya Nagrik Suraksha Sanhita. Earlier it was CRPC. Section 144 of CRPC used to be curfew. Now we all know that CRPC has been replaced by BNSS. So now it is 163. So remember these two sections also. Clear? Now what is the statutory framework? Who has the authority to impose curfew? You need to know everything which is written in the law. Clear? So section 163 empowers a DM or an SDM or an authorized executive magistrate to impose curfew in a particular area. Clear? What are the grounds on which curfew can be imposed? Because this DM or SDM have to justify their order. So on what grounds can they impose a curfew? Obstruction, annoyance or injury to any person lawfully employed by the government. Danger to human life, health or safety. Disturbance of public tranquility, riots or affrays. Okay. So these are the grounds. Basically public order. And scope of order. It can direct any individual or general public to abstain from a specific act or take specific order regarding property in their possession, which means they can ask the general public to not travel from this road. This is the scope of the order. People can't say that you are violating my fundamental right to travel from anywhere. No. If section 163 is in place, government can prohibit you from traveling from a particular road, okay? Or the government can order you to close down your shop, your property. That can also be done. And these orders can be ex parte. Now, what do you mean by ex parte? So, whenever court gives a judgment order, it listens to both sides. But when the courts listen to only one side, those are called ex parte orders. Now, DM, SDM can give ex parte orders also without hearing the side of the protesters, just listening to the government reports and pass this order. This is totally legal. Clear? Plus, it is valid up to 2 months. The state government can extend. Because why state government? Well, because law and order is a state subject. Can extend the order for a maximum period not exceeding 6 months under special circumstances. Right? Now, actual usage. Well, it is generally believed that Section 163 is imposed only during riots or public order disruption. But Delhi police, 43% of the times has used it for seamless services, okay, courier services. Well, most of the times for public repair or CCTV installation. So what happens is that, well, if you want to install CCTV cameras on the roads in a particular area, you need to stop traffic. So you issue 163. Very few times you issue it for protests and public demonstrations. Okay. Constitutional limits. You can challenge this curfew order in a court. Okay. So there have been various Supreme Court judgments. Babulal Parate, in which the Supreme Court said that it is an emergency only power. You can't issue curfew orders just like that. The court reiterated its stand in Anuradha Bhasin case and Mazdoor Kisan Sangh Samiti case also. Okay, that you have to issue curfew orders only in rare occasions, only on rare occasions. Clear? And in the end, this table is given in your notes. Okay, so this is the actual law. And this is the allegation of misuse by the police. Okay. So in the actual law, when can it be triggered, duration, protest management, constitutional alignment, all of that is mentioned. But people allege that it is sometimes misused by the government. Their arguments are given in this last column. So do take a look at this column also. It is given in your notes. Right? And that would be all. So with that, we conclude today's session. So thank you so much for watching, everyone. And I'm sure it has added value to your preparation. But to add more value, you have to be consistent and regular with this lecture series. And number 2, revise this lecture from the notes provided by us. This is really important. Spend those necessary 15 minutes revising this lecture from the notes provided by us. All right then. On that note, I shall take your leave with the promise of seeing you again with another set of news items. Thank you, everyone.